I want to thank everyone for being here. Today's Civil Justice Full Committee's meeting. And Madam Clerk, if you go ahead and take the roll for us to get started.
Representatives Bricken, Clemens, Curcio, Eldridge, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Russell, Smith, Stewart, Vice Chairman Jernigan, Chairman Farmer.
Present.
Mr. Chairman, you have a quorum.
Okay, thank you. And members, before we get started, anybody have any personal orders, any announcements or anything they'd like to take a moment to recognize anyone or anything? Okay, seeing none, looks like we're ready to get started on our calendar. We have item 1, that's House Bill 1832 by Leader Lamberth. You got a motion and a second, sir. So you're properly recognized. Do we need to adopt an amendment here? It doesn't look like we do. So do you want to go ahead and do your thing?
Thank you, Mr. Chairman. I just want to say it's a very simple bill, and it literally does exactly what it says. It sets up a task force to look into judicial redistricting, not for this year. All these folks are running right now, so the judges and DAs and public defenders. But, I mean, these lines have not been touched in decades, and it's far, far past the time when somebody should really sit down and look at this and come to us with a plan that involves the input of the public defenders and the DAs and the judges and the public, and really dig into this and figure out, before the next election cycle comes up in 8 years, how can we properly do redistricting that we do every 10 years for us? How can this be done in a way that, would make sense? That's what the bill does.
Very good. And members, I'm going to open this up for questioning. First on my list, I have Representative Stewart.
Just a technical question. DAs and the public defenders, have they been consulted? Are they on board with this concept?
Leader?
There are 3 district attorney positions on the committee and 3 public defender positions on the committee.
And I take it, I'm just wondering if those organizations, they lobby up here and so forth. Do you know how they feel about this? I assume they are for it, but.
Yeah, you're recognized.
Thank you, Mr. Chairman. I have not heard from either organization. They have been a part of all these processes in the past. As a general rule, I think I can state their position as normally being against redistricting in general. They all have their districts. They know their districts. They don't really want their districts to change. We probably all felt exactly like that when we went through redistricting this year, and yet redistricting happened, and roughly 20% plus of my district has now shifted. And I hated for those constituents to not have the opportunity to make a decision as to whether or not to vote for me this November, but they are now in a different district. So, that's redistricting. So I think the DAs and public defenders and judges most of the time will say, hey, we'd rather just not redistrict at all. But from a public policy standpoint, we've made sure they have a seat at the table if we were to redistrict down the road where they have input. So I hope that summarizes their position, but they've not reached out to me one way or the other on this.
Representative
Okay. That's all. Thank you, Mr.
Very
Chairman.
good. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And thanks, sponsor. We discussed this briefly last week in subcommittee. Would you be amenable to, you've got the Speaker of the Senate and the House making all these appointments. Would you be amenable to allowing members from both parties to make these appointments? Because I'm worried about the increased politicization of the judiciary, and with just one party potentially making all the appointments, that just concerns me. Would you be open to that or no?
Leader, you're recognized.
Not at this time. I appreciate the thought, but the speakers are elected by members of both parties. In fact, we're overwhelmingly elected by Republicans and Democrats for our House Speaker and the Lieutenant Governor. So, they do represent both parties as speakers, and this is a House and Senate committee. So it would, by having the speakers appoint these, both parties are represented in that process. And I do hope that, both speakers would look at, when appointing these members, folks from obviously different geographic areas and backgrounds and political affiliations and everything. Everybody should have a seat at the table on this, and I will encourage that at every step of the process, that, this isn't a partisan issue. When we do redistricting, it should be bipartisan, be it for the redistricting process we just went through, or especially when you're talking about, judicial redistricting and how we do that process.
Representative Clemens, any follow-up?
No, thank you, Mr. Chairman.
Okay, very good. Next on the list, I have Chairman Curcio.
Thank you, Mr. Chairman. I apologize for my tardiness. Thank you for bringing this bill, and I thought I had signed on to it. I see that I have not, so I would like to do so. But I want to do so by making this comment, which is I have been looking at the weighted caseload study for the last 6 years. I've had a bill every single year to try to fill the deficiencies in that weighted caseload study. And this year, the Administrative Office of the Court actually requested funding for 5 judge positions to be created. And I'm proud to be carrying that legislation. Unfortunately, that did not wind up in the governor's budget. I do not know why. I wholeheartedly support this effort, and I know anytime we talk about bringing more judges, the constant or the common refrain is, well, we need to reapportion, we need to redistrict because we've got some districts that are overjudged, some districts that are underjudged. I am for this fix, but it takes effect 2031. I have cop killers and people that we have the audacity to call parents who have murdered their children awaiting trial in Dixon County because we don't have enough judges today. So I cannot wait to sign on to this bill, and I really appreciate your efforts for it. But if there's anybody listening that's questioning whether or not those 5 judicial positions need to be filled this year, I'd like for them to think about that. Cop killers and people who murder their children are not getting trials in my district because I don't have enough judges. So thank you very much for your work, and I look forward to helping you get this passed.
Leader Lambert, you recognize, sir.
And Chairman, thank you for saying that. And I will tell you, the governor proposes a budget. It is filed like any other bill, and it goes through the committee process like every bill, and it becomes our budget, the voice of the people. So the House and the Senate votes on that budget, and we add in whatever is necessary specifically to effectuate justice and so that the people of this state get good service from the taxpayer dollars that they pay in. So I've mentioned to you, I've said this before, and I'll say it publicly now, I fully support the addition of those 5 judges. I think they are desperately needed, as is redistricting statewide, because the way it's done now, it was not, these districts were not set up really based on a weighted caseload study, as was previously mentioned from my friend from Davidson County. Partisanship eked its way into the redistricting process when this was originally set up, and you can look at the lines as they were drawn then, and it is very clear that partisanship and politics went into how these lines were drawn. It should be drawn in a way that takes into account geography and weighted caseload study, and even just where the central kind of hubs of communities are. And we've had these conversations before on how you can access that. I mean, we have a 1-county district in my district. This judicial redistricting would probably not affect us one way or the other, but Gallatin is where the courts are. That's the hub of the county. It's easy for folks from all parts of the county to get there. There's lots of points of ingress and egress and everything else. So that's the type of thing we're talking about here, is so that this is done in really a not just a bipartisan, but a nonpartisan matter, so that it works for the people of Tennessee. So those folks can get a fair trial, and if they are convicted, they can face whatever sentence is appropriate in those cases. And my staff's watching. I bet there will be a sign-on form delivered to your office very soon, Mr. Chairman. Thank you.
Thank you, Mr. Leader.
Very good. Members, Representative Griffey, you recognize.
Thank you very much. Thank you, Chairman, for bringing this, Leader Lambert. When would be the first time this committee would meet and would start making considerations?
Leader Lambert, you recognize.
So by no later than July 1st of 2031, the committee is to be appointed, and they have to return findings by no later than January 1st, the following January 1st. If this bill is successful through the process, I hope and pray that the speakers will not wait anywhere near that amount of time to appoint this committee. That's the latest it could meet. It could start meeting as early as, next year or the year after. I mean, it, obviously will not affect these lines. I mean, for the folks that are running for judge right now, but they could meet as early as they want to.
Representative Griffey, any follow-up?
Thank you. The reason I brought that up is there was a committee, and they met last year before, and they made recommendations and proposed some changes, left some stuff, and I know that there was still some discussion in those meetings about the number of cases that are counted, how they're counted, whether general sessions are going to be brought online to see how much that is pushing the judicial resources, and maybe some judges are, making indications they really don't want some of these cases up in the circuit court or whatever, and that can impact the caseload and weighted studies. And I just didn't know if you had any comment to that.
Leader Lambert, you recognize.
Well, I've sat on at least 2 different task forces and committees over the last 10 years that have looked at this. They've taken into account much of that, and it all should be taken into account. It's just time we get serious about this. I mean, it's come up over and over and over again, and let's get a committee out there. Let's really have them look at it, and then if any of us are blessed to still be here when they come back with the report, let's vote on it and get it done. I mean, so, yeah, everything you've mentioned needs to be taken into that, but let's set this process in place and let's get it done.
Yeah. Representative Griffey, any follow-up? No, thank you. And I have a quick question, and just popped in my head. Where is the information that everyone worked so hard on to put together? Where's that? Where's it? I think we've done this. Where's this information at?
Many times it goes into a report that is delivered to our offices, and I will only assume that everyone on this committee has poured over those reports in detail and has that preserved somewhere on a shelf, because those definitely have been received in the past, and there's a lot of good information there. It then goes most of the time into the archives, and so we can still obtain some of that information from the past. Much will probably have to be recreated, but I mean, some of that, there's some really good data out there. That has been prepared by task forces and committees in the past. I hope we can draw on that and build from it.
Good. Okay. Representative Ricken, did you want to question? Gillespie, did you have your hand up? You're recognized.
Thank you, Mr. Chairman. Leader, thanks for bringing this. I just have one question. I know that the task force will be composed at various levels from citizens from all three grand divisions and judges and et cetera. My only concern is, I'm from Shelby County. I represent parts of Shelby County. Shelby County is very different from Tipton or Fayette County. If, let's just say, there's more population loss in the future, I just got to look out for the needs of Shelby County are very unique to other parts of West Tennessee. And I just want to see if you have any comment on that, or if you can add anything to that, just to.
Great. Leader Lambert, you're recognized.
Only that, obviously it's a task force, and, any report from that task force, just like we've mentioned other task forces have, would come back to this body. You're a valiant soldier and warrior for your district, have been since the day you got here, and hopefully will continue to be for many years to come. I can't imagine a judicial redistricting conversation and a weighted caseload study or anything else that does not involve a conversation about Shelby County and Memphis in particular. So I don't have any concerns that would be somehow left out. Normally the concern has been, quite frankly, that many of the rural communities do not have the voice. It focuses on kind of the big four and the suburban areas around them. So your big four metropolitan cities. Usually the greater concern has come up on these task forces in the past is how do we make sure rural communities have the amount of representation that's needed on here, because they have some unique challenges as well. Sparsity of population being one of them, on how do you form a court system around a hub when there's no particular hub. In Shelby County and Memphis, that's not necessarily an issue, but in other areas it is. But yes, definitely need a seat at the table there to make sure your folks are well represented.
Very good. Representative Gillespie, any follow-up? No, thank you. Very good. Members, anyone else have any questions? Representative Garrett, you're recognized, sir.
Question on the bill.
Very good. Question's been called. Any objection? Seeing none, looks like we're going to be voting to send House Bill 1832 to Finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and members of the committee.
Very good. The next up is item 2. That's House Bill 1472 by Representative Ogles. And you've got a motion and a second, sir. It looks like I've got an amendment here, 005635. I can't remember if that makes the bill or just how we adjusted that down. Got a motion and a second, so you're probably recognized on the amendment, sir.
Thank you, Chairman, members of the committee. I'm actually going to ask to take this off notice. I've got some more work to do on this, but I would like to briefly describe what this does. This piece of legislation expands criminal asset forfeiture to include involuntary labor servitude, trafficking, and forced labor and service, trafficking for commercial sex acts, aggravated rape, rape of a child, and members. We take people's assets for drugs and some other things, and I just want to be sure, like going forward, that some of these heinous crimes, anything that's used in the act, commission of the act, any assets or homes that are involved with some of these most egregious crimes, I think these have a huge impact to our society, and in many ways are equal to, if not more, horrendous than trafficking of narcotics. So I would hope that we would, when available, seize those assets and use them and put them to good, and specifically enable them to go to restitution to the victims. But I've still got some work to do, so I would request to take this off notice, but I would also subject myself to any comments from the committee or advice going forward. Thank you, Chairman.
Very good. Members, you heard Representative Ogles. Anybody have any comments or advice for him? Seeing none, he's requested that to be taken off notice. Any objection? Seeing none, House Bill 1472 is off notice. That brings us to item 3, House Bill 2046 by Representative Bricken. You got a motion and a second. I don't see an amendment here, so sir, you're recognized.
Thank you, Mr. Chairman and committee. This bill is pretty straightforward. It basically changes the code to permit each child protective team to include one appropriately credentialed medical provider to be added as a member of the protective team. So that's simply all it does.
Very good. Great explanation. Members, any questions or comments for Representative Bricken on this piece of legislation? Seeing none, looks like you've done very well explaining that. So it looks like we're ready to vote. Send House Bill 2046 to calendar and rules. All those in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on. Very good. That brings us to item 4, House Bill 1866 by Representative Cassida. And you've got a motion and a second, sir, and I see an amendment here, 013132. Would you like to adopt that?
Amendment makes the bill.
Very good. Amendment makes the bill, and you've got a motion. I heard a second as well, so you're probably recognized.
It simply states it just gives the judge one more factor in deciding child visitation. That's all it's going to do.
Very good. Members have any questions for Representative Cassida? Representative Stewart, you're recognized.
Just a question, does the amendment itself make,
And it makes
it leaves it to the judge the judge is still making the decision, it's adding a factor to the calculus, is that correct?
That's correct. If you go to 106 and read down, this is yet one more item in that list that's under 106 of what a judge can use to allow for visitation.
But it's not
determine.
mandatory.
That is correct. Just like the rest of 106 is not mandatory.
Right, it's just one tool the judge can use.
That's exactly right.
Okay.
So again, gentlemen and ladies, if you look at 106, there's a list, and this is one more item that's to that list. None of those things are mandatory.
Very good. Any follow-up?
No, Mr. Chairman.
Very good. Representative Clemens, you're recognized.
Yeah, thank you, Mr. Chairman. I was just curious how we landed on 3 years or more. Where did that number come from?
Seemed like a fair number to me.
Representative Clemens, any follow-up?
I don't know how you follow that up. Thank you, Mr.
Very
Chairman.
good. Very good. Well, I bet Representative Garrett would know how to do that. You're recognized.
I prefer it be 3 seconds for a deadbeat dad or a deadbeat mom to not pay his child support. But Representative Clemens asked my question. I was just kind of curious. And 3 years seems like a long time. There's a lot of folks that don't pay child support, which drives me insane. But I'm just curious. Other than I do agree that that's a reasonable amount of time, but that's that's 36 months for a mom or a dad not to receive child support. And that can get, in the thousands and thousands of dollars. And in my opinion, why not 3 seconds? Why not the minute you're late? That's a factor whether or not you get to see your child or not.
And I'm here at the will of the committee. When I read through what other states did, 36 was the second shortest. There were several states that had 36 months. And I thought, why reinvent the wheel?
Right.
So I just went with what other states have done.
So and again, I'm not trying to, I wholly support this bill, but there wouldn't be any opposition from you if that time frame might be shorter, like 12 months or
That's right.
something like that for the judges to consider as a
If you
factor.
guys want to make it, I am very amiable to make it shorter. That's how I came up with the 36 months. But no, I'm very amiable to make it less than that.
Well, I think the bill looks like it's moving along very, very well right now, and we're in the full committee, and that would be a substantive change there. But I think maybe we see how this goes, or if a member wants to bring an amendment, try to amend it, that's fine, but it would need to be in writing at this point in time, so.
Well, thank you for bringing this legislation. I fully support it, but
Yes,
thank you.
Okay, Representative Griffey, you're recognized.
Thank you very much, Mr. Chairman. I appreciate you bringing this bill, and I would just advocate to the committee, since this is just going to be a factor for a judge to consider, that allows him to consider, I think maybe a shorter period might be appropriate, and maybe it gets amended somewhere along the line. But if you're a whole year late, you haven't contributed to child support, I think the judge ought to be able to take that into consideration. Get the dad or the mom who's ever not paying the support in there and say, what's going on? What's wrong with that? That can impact my decision, how much you're going to get to visit your child. And, I think most judges, we don't want to restrict a child's time with his parents if they financially don't have the ability to pay or run into financial difficulties or something like that. But if you get someone that's willfully not making the effort and doing something, I think the judge ought to have that ability to take that factor into consideration. I would just throw that out there for the committee's consideration. Thank you for bringing this. Thank you, Mr. Chairman.
Any follow-up, Representative Casa? Any follow-up to that? Okay, very good. Next on, let's have Representative Parkinson.
Thank you, Mr. Chair. And Mr. Chair, I apologize for being late. This is a tough one for me because I think we really need to start taking a look at, what will make the most difference in a child's life. Is it the time that that parent gives and spends in nurturing and building and teaching, or the finances? And I know there's a need for both. I know both are vitally important, right? But but I want you to think about this now. We hear all the time about, these children that have gone wayward, and then when we look back at it, a lot of times it's because the fathers are not there. And this, based on what I understand about this bill, this will create another avenue to remove a father. And I'm telling you, we are suffering from a not pandemic, but from a plague of issues, whether it's incarceration of the father or it's, wrong fathers, and of those that male figure not being in the life of that child. And so I really think that we need to really think about what we're doing here and find ways to get the father into the child's life and having more time with the child, as long as it's not a danger to the child or the child's mother. Yeah. And so I just want us to really think about that, as we contemplate this piece of legislation. Thank you, Mr. Chair.
Mr. Chairman, I think Representative Parkinson is spot on. The genesis of this bill was after 36 months, you lost visitation rights and parental rights, and met with chairman of the subcommittee and met with several attorneys that practice family law, and they felt like that maybe just one more item to help the judge consider. So it's not meant to Representative Stewart, Clemens, whoever's made the point. This is not mandatory. It's just one more factor a judge can use in determining visitation rights. So.
Yeah, follow up. Go ahead.
And thank you for that. And I understand that, but why do we want to add any more tools to remove a father, versus adding tools to put a father in place? To give more time, because depending on and I'm assuming based on this legislation, and forgive me for assuming, and maybe you can help me out factually, that if this father has not paid, right, for 36 months, 3 years, the judge can then say, based on this, if this legislation passes, he can use that as a factor to end visitation, right? But if this father, he hasn't paid, but he spent time, based on this law, the judge can still use that 36-month factor as a reason to remove almost the parental rights of this father. And then how do we should have, or we should address also that child's right. We talk about children's right to live, and I'm not trying to cause any turmoil here. I promise y'all, it's not a dog whistle. But children do have rights, and those children do have the right to spend time with their father, or both parents, especially if there's no danger to anyone, And so to put this tool in place, we have to think about the child's right. What right does that child have to see their father? And so to put this in place is, I think we're going down, the wrong road. And Chairman, you're a good friend of mine. I think we're going down the wrong road with this one.
And members, we need to remember there's several factors that tie us to that relationship. So if a father is visiting, number one, number two, talks about child's relationship with each parent. There's 3 or 4 of the factors that go directly to that, right? What you just said. What if a father's visiting for 3 years but hasn't paid? So there's several factors in there that would go to as a plus for the dad or whomever is not paying child support. So Yes.
And after those factors, does the judge still have the latitude to ignore those factors, though? And see, that's what I'm saying. But even with those factors, even if he's to look at those factors, yes, he's been spending a lot of time with this child, but he still has the latitude to snatch that child's father out of his life, even considering all of that. And I just think that I don't know if we want to give anybody that latitude and versus us focusing on, let's find a way to make sure that he supports financially, but don't remove him from the life of the child. That's what our crime issues and penitentiary issues are derived from immediately right now. Okay. Thank you, sir.
Very good. Next on the list, I have Representative Garrett.
Thank you for the points, Representative Parks, that you're bringing up. In any custody issue, one single factor is not going to eliminate any parent's time with the child, whether it's mother or father. It's in this particular situation. This is simply one factor that can be considered as a whole. I believe rarely will a judge, if this becomes law, will be the only factor that will come into play should the child support not be paid. These are factors that are going to be discretionary, not compulsive, where the judge has to say, you're no longer going to see your son or daughter because you're not paying child support. This is simply one of the factors that can be. My hope with this factor being part of this is that it would put child support as a priority to be paid instead of paying off your phone, paying off your cable bill, or paying off whatever's out there, that actually your child support obligation will become a priority to be paid in someone's expenses rather than something else going to Shoney's or going to McDonald's or whatever the case may be. It's just where you see folks spending their money on places that are not priorities. So my hope is that this will be a priority in a household when they have an obligation for child support, because that goes to housing, that goes to food, that goes to clothing for these kids. So I think that that's just one of many, many factors that can be provided to the judge to make a determination about parenting time. Rarely do you receive any mother or father when you're in a custody battle to not get any time. There's got to be egregious behavior on behalf of that father or on behalf of the mother before there's zero time that the child will have with either parent. So I just want to make sure for the record that we were aware of that. Thank you.
Very good. Any follow-up? None. Seeing none. Chairlady Littleton, you're recognized.
Thank you, Mr. Chairman. I certainly think a father needs to be involved in every child's life, but that child also has to have food, a home, a place to live, clothes, shoes, everything. And also, he needs an example from each parent of how to become a productive citizen. And if you're not paying your child support, you're not teaching that child how to be productive and to take care of their children when they have children. So every person that needs to pay child support should pay the child support. That's their love right there, is taking care of that child, not going and playing with them and giving them things that the mom can't give them because she doesn't have the child support to pay for it. So showing the love is showing the example of how to be a productive citizen when they grow up. So.
Excuse me. Next on my list, I have Representative Eldridge. Recognize her.
Thank you, Mr. Chairman. In listening to the conversations around here, and I guess this is more of a comment, I think we're trying to assume that a parent is involved in a life if if they've waited 3 years or if they've gone 3 years and they've not paid child support, then they've not been a parent. They've not been active in that child's life, in my opinion. If they care about that child, they're going to want to take care of it, and they're going to want to be there for it. And child support is a major factor in that. And that is, I mean, anybody can father a child, but it takes a special person to raise that child and be a part of that child's life and taking care of it financially. And in my opinion, someone who has not paid child support for any length of time, as Chairman Garrett alluded to, they're not being a parent. And that's just a comment, Chairman.
Very good. Any response, sir? I know. Oh, hey, we're getting there. We're getting there. I promise. I promise we're getting there. Representative Ogles, you're recognized. Oh, Representative Ogles, you recognize?
Yes, sir.
Okay, got you.
Thank you, Chairman. I think we've exhausted this.
Very good.
Thank you.
Chairman Russell, you recognize, sir.
Thank you, Chairman. I just had two questions. The first one is partial payment defined as not paying child support?
Right. And I'll go out of session if no, without objection to have that question answered.
Michelle Fogarty, Legal Services. The code talks about token child support, but there's no, this bill does not address whether the payments are partial or full. It just,
Chairman Russell.
Okay, I'm not sure if this will be a question for legal or the sponsor, but if an individual had the visitation rights taken away for not paying child support for 3 years, excuse me, at what point can the visitation rights be reinstored? Is the total payment of the 3 years back pay?
Let's ask legal if you have an opinion on that, or if it's in code, I guess.
the language of the bill does not address that.
Okay.
The language in the bill does not address any of that, but a person can file a modification of a parenting plan and request additional parenting time, and they could present evidence showing that they have been paying child support.
And if I understand correctly, that would be up to the judge.
Yes, sir.
Thank you.
Okay, very good. Anyone, any members, any other questions for legal while we're out of session? Sure, Representative Parkinson.
And Mr. Chair, I guess it's for legal, so, or maybe for the sponsor. So if the person has had his visitation removed for not paying child support for 36 months, is he still bound for the child support under this legislation?
This bill does not speak to that, but generally a person is obligated to pay child support until the child turns 18 or the class of which they are a part has graduated from high school.
Sure. Okay, thank you, sir. Very good. All right, very good. Any other questions for legal? I'll go back in session, and very good. All right, see you none. We're back in session, and I'm going to recognize Chair Lady Littleton. I think she may have something to.
Thank you,
may
Mr.
help us
Chairman.
out.
A few years back, we passed legislation that said if a parent is behind in the child support, that if both parents agree, the judge agrees, and both attorneys, that the parents can come to a settlement, and the parent that is behind in the child support can pay whatever they agree to and then take up child support. So we did that for some that were so far behind. Did that make sense? So they can, if both of them come to a conclusion of a settlement of what is owed, child support that's owed, then that parent can pay that and then start their child support over. That makes sense?
Yeah.
Okay.
Okay, and
And that did pass. That is legislation.
okay, very good. Chairman Russell, I interrupted you there. Did you have any more questions for the sponsor about? We're still on the amendment, folks. We're still on the amendment, but it makes the bill. So
I just want to thank the sponsor for bringing this legislation. I think it's going to be an incentive for people to pay their child support, so I'll be voting for it. Thank you.
very good. And last on my list, I have Representative Stewart. Withdraw. Representative Griffey, I saw your hand. I'll be right back to you. Chair.
Just quickly, I have had some experience this in court. I've had a client, had 5 different kids from 5 different moms, and didn't pay any child support. He was constantly in court. Taxpayers are picking up a lot of that burden, the Tennessee taxpayers. And, in today's economy, there's no reason somebody can't get out and get a job and work for their kids unless they're, physically disabled or something like that. So I just want to bring it to committee's attention. Thank you.
When I was walking down the street, had a guy come up and ask me for $20. I said, well, go down and get a job. You can make $20 an hour. I said, you can have it an hour. Representative Harris, you recognized.
Thank you, Chairman. So I do have one question and one comment as well. But for the question part of it is, does this take into consideration those who are incarcerated? Does this count the 3 years that they may be incarcerated as well, or is this just outside of that?
Representative Cassidy, you recognize.
It's probably best if I let legal answer, but the context is it's just a factor the judge can consider. And so the other factors that are out there, this bill doesn't address. But obviously, Chairman of Legal probably would give a much better legal answer than I just did.
And I don't think this legislation speaks to that. And plus, if you're incarcerated for 3 years, you're not going to have visitation anyways. So I can go out of session and let legal answer that if you'd like, or whatever. Okay, very good. And members, I've exhausted the list. Are we ready to vote? Wait, you had another question?
And I did have one comment to also mention. I have a constituent that's watching as well, and I just want to make sure that I address their concern too. A lot of times, as I was listening to each person speak, we mentioned it as if fathers are the only ones that this addresses, and so I want to make sure that we know that this is for both parents, and that sometimes mothers also fall into this situation as well. So, thank you.
Very good. All right, members, we're ready to vote to adopt this amendment. All those in favor of adopting House Amendment 013132 to House Bill 1866, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Are we ready to vote? The question's been called. Seeing no objection, we're ready to vote to send House Bill 1866 to calendar and rules. All those in favor, say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. And that brings us to your calendar rules, sir. Calendar and rules. Thank you so much. Item 5, House Bill 1666 by Representative Smith. Motion. Got a motion second, ma'am. You're properly recognized.
Thank you, Chairman and committee. This bill is looks like a caption, but it's not. And looking at its caption, this is relative to divorce and domestic cases. This is permissive. The court may order a mediation between parties to take place by video conferencing when appropriate. Again, it's just permissive, and 2 judges from Hamilton County brought this to me, and it's an honor to help them facilitate good family law.
Very good. And first on my list, I have Representative Stewart.
Yeah, just thinking about this is a good bill, and it's going to save some people a lot of money. Divorce, a lot of times, is very financially difficult, and so anything we do to save people money in that situation is good. I don't practice family law, but I know it can be very emotional for people, and I imagine putting the distance between people in that situation is also a good idea. So it sounds like these judges have a good idea, and I'm looking forward to voting for this.
Very good. Next on the list, I have Representative Garrett. You're up, sir.
Thank you. I've got several concerns about this. I've participated in hundreds and hundreds of mediations between folks that are divorcing. And judges don't, by the way. They're not in the room. And so I get that this may be a money saver. I tend to disagree. Here's why. If you are in the room and mediation is set up where you're in 2 different rooms and the mediator's going back and forth between rooms, typically in a divorce situation or an alimony situation or a child custody situation, you have what's called a marital dissolution agreement. You have a permanent parenting plan at the table. You are reviewing it, you're there, you read it. For me, if I was a lawyer representing a litigant and my client wanted to participate in a video conference or a telephone conference in mediation, I would withdraw from the case because you're not going to get an agreement done. They can hang up by phone, you can turn Zoom off, and you walk away. And I'd say 98% of my mediations settle because you're in person. You were there, the parties are worn out. Usually there's kids involved if it's a custody issue, and the job of the mediation or the mediator is to reach an agreement. If you're looking at a screen, you can't read their body posture. You can't read how they're reacting to certain offers because you're not there in front of them. Is the mediator on screen? Are both parties at home in their pajamas? Are they treating it like it's a real act of trying to get something settled? I advise my clients, if we go to mediation, you have to be prepared to give up something when you go to mediation. That's the very virtue of a settlement. I tell folks that if you leave a mediation and you are happy, if your client is actually happy out of a mediation, then that probably wasn't a great settlement, right? Because both parties need to be kind of ticked off if they leave a mediation and they're not happy. That means it was probably a great settlement. My issue with this is that this is not going to cause parties to settle a case if they're not in a room. If you are dismantling a partnership, and that partnership is a very value partnership, which is what a marriage is, right? By law, it's a partnership. If you are dismantling that partnership and you're doing it in a video conference room in your house, in your home office, or wherever, you're not going to be paying attention and inclined to get that resolved. I think this is a very bad idea because I don't believe and have confidence in being able to mediate a case and get done if I'm doing it by TV. And so that's my concern with this legislation. It's the first time I've seen it because I actually do this, and I would have difficulties if the parties filed a motion with the judge, and the judge ordered mediation, but then he put conditions on the mediation that we've got to do it by Zoom, which none of you ever, I'm not saying taking a deposition by Zoom, doing things that we do as lawyers to provide the best case we can for our clients, doing it by video conference, you're making the process more difficult. This would make the process of trying to resolve some of the most contentious cases that we have in our judicial system, which are divorces, this would make it more difficult. So I'm sorry, but I won't be able to support the legislation because I think practically it will not work. So thank you.
Good. Representative Smith, any follow-up?
Yes, sir. Thank you so much. And now I'm hoping that my judges back home in Hamilton County are watching so they can note the very disdainful opposition noted by one judge, attorney, Mr. Garrett. So noted. But I would ask the committee to consider that this is permissive. It's not mandatory. And I do think that judges are absolutely in a position that they work together with the plaintiffs and the defendants in something like this. Again, very permissive. I have no invested interest in this, don't practice law, but when two judges come to me requesting something to enable their practice in their courtroom, I'm obliged to do that for my folks back home. So thank you, Mr. Chairman, for a follow-up.
Very good. Chairman Russell, you recognized.
Thank you, Chairman. And sponsor, was this allowed to be done during the state of emergency during COVID?
Representative Smith, you recognize.
That's a great question, and I do not know the answer to that. Happy to let legal opine on it. I'm not aware of, or another attorney on the panel.
I didn't participate in any during COVID, so okay, and I believe the answer is yes, according to Attorney Clemens over there. So, is that Chairman Russell, you recognize?
Okay, and just to clarify, if the two parties can't come together on a mediation during the video conference, is there anything preventing them then to do an in-person mediation, or how does that work?
Right, Representative Smith.
100% permissive. If the parties don't agree and the judge can't gain agreement for the parties to participate, then I would imagine the logic tells me that they would be ordered to come and participate in person.
Right.
There was a lot of terrible things that happened because of COVID, but I truly believe like telehealth was a good thing, and I think this would be a good thing also, so I'll be voting for it. Thank you.
Very good. Representative Griffey, you recognize, sir.
Thank you, Mr. Chairman, and all the due respect and deference to my good friend next to me. I trust our chancellors and our judges, and this is permissive, and I can foresee a situation where, we've got a couple that are splitting up, and one of them's traveling, and, it might be, a little time out before somebody could get back, and there's expense involved with that, and, if, the parties might even agree that we'd like to do a mediation, by, let this party participate by phone, and if the judge is agreeable, and, they can always try it, And if it doesn't work, the judge go, well, that didn't work. I'm going to order you guys to show up in person next time. That's the way the, cookie crumbles. And, you do that. So I think this would give some flexibility, and I think we've seen that technology has gotten to the point with COVID that we can conduct meetings. We don't always have to be face-to-face, but, I prefer doing stuff face-to-face with like my friend, but I'm in favor of the flexibility. We can at least try it and see if it works. If it doesn't work, we know to come back and change it. So thank you, Mr. Chairman. Thank you, sponsor, for bringing it.
Very good. And I had, just from personal experience, I participated in two. Well, I was there, and my client was at the mediator's office, and then we had the opposing party on Zoom. One of them was a disaster, and they just kind of checked out, as Representative Garrett said. It was a waste of time. The last one was last Thursday, and my client and myself were at the mediator's office, and the other attorney was actually here in Davidson County. Her client were both on there. It went very, very well. We was able to settle the case and even sign the documents by DocuSign. The mediator sent them over. They came right back. We signed everything there that day, which is important because you don't want anybody having buyer's remorse and leaving and saying, well, I don't want to sign this. So it worked out really well. So for what that's worth, I'll let if you
Well, and I just, again, it's permissive. I think that the term judge reveals what they do. They discern, and they apply the construct around the law to facilitate the outcome. And again, if I were a trained lawyer, I could probably opine and be a little more technical, but I just think that, as my friend Chairman Russell has mentioned, it works well in medicine in appropriate areas where you don't do heart transplants and certain things by telemedicine. I think this can just be a facilitator. But thank you again for the indulgence, Mr. Chairman.
Members, any other questions? We're ready to vote. Representative Ogles, you recognize, sir.
Thank you, Chairman. I just want to remind the committee that last year we allowed even criminal evidence to be submitted via remote testimony from our state crime lab. So we've on the criminal side, we've permissively allowed judges to allow remote testimony and some remote evidence to be submitted, which was a big step forward. So I feel like COVID has kind of pushed us in that direction already, and it's going to be hard to, as Representative Garrett said, there's definitely going to be some growing pains and new processes, but I'll also be supporting the legislation.
Very good. Representative Clemens, you recognize, sir.
Thank you, Mr. Chairman. I was just going to provide some clarifying information to some of the questions that were asked, but it sounds like we're going to pass this, so it's probably unnecessary. Thanks.
Very good. Vice Chair Jernigan.
Question on the bill.
Very good. Question's been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 1666 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Bill passes. And that brings us to the what a boisterous opposition over there. All right, that brings us to the end of the committee. Without objection, we're going to adjourn till this time next week.